Greetings and good morning. Been feeling a little under the weather lately. I'll be alright. I will survive. Wanted to talk to you guys this morning about some of the shit that went on in court the other day, which was an absolute shit show. I mean, from the alleged judge prompting the prosecutor to object, to him sitting on the bench asking discovery questions, which you always got to shut that shit show down. I just couldn't believe how boisterous and bold they were. But one thing I want to say is nobody's immune from taxes, all right? And because of that, I don't mind being the underdog. I have no doubt in my mind I will prevail in this. The thing is, the securities, the rights, titles, and interest is something that I'm not just going to walk away from. Most people like to get rid of cases, and that's all cute and fun and cool, but there is something on the backside of those cases that people are missing. They just don't understand how the securities and negotiable instruments work. And if you go to Treasury Direct online, you can look up any of your cases, and you can see that they're monetized. And then, of course, you go, I believe it's 100 times the value or 10 times the value. It's 100 times the value or whatever. So the case for me reads as though only 5,000 has been monetized, but when you really look it up, it's 50 million. And somebody's got to pay the taxes for accessing that. And we find that to be true in Title 26, 2603, 2203, 2002, and Title 26, 2032, AE11. Now, I know these people are scared of that shit because, hell, I'd be nervous as a whore in church if I had somebody like myself coming after me knowing these things. So one of the other things that I like to utilize in court now, of course, they try and make the whole record disappear as though it doesn't exist. They throw out all the paperwork. It wasn't filed properly. Well, equity disregards the form and looks at the intent. And so if I have to go into the exclusive jurisdiction of equity to find remedy, that won't be hard. Secondly, it can't be criminal. None of the cases are criminal. Even though they allege to be criminal, they're all civil in nature. So that takes you back into a different venue. You can't be in the district court because it's not criminal. It's a contract dispute, and because it's a contract dispute, it's a civil matter. But they like to play it off as though it's some type of a criminal activity that you've been engaged in, but realistically, it's a civil matter. So let the record show no plaintiff has made a general appearance with sworn testimony filed and bonded in this instant case. Let the record show the defendant reserves all his rights, waiving none. Let the record show defendant does not waive his Sixth Amendment right to face his accuser. They always tell you when they're reading your alleged rights that you have the right to face the witnesses and cross-examine them. They seemingly over 800 years have forgotten the fact that you have a right to face your accuser, and without the accuser being present, there is no case. It's a claim being brought forward for which relief cannot be granted, and it's malicious prosecution. And the fact that the prosecutor isn't bonded properly with the Secretary of the Treasury in Puerto Rico under Title 2032 AE11 carrying an independent bond, you need to request the 433A and 433B be filled out. So when you wrap this all up and they finally dismiss it, whether you're going at them with the IRS or whatever, and I'll tell you right now, when you go at them with the IRS, they will shut shit down. Why? Because the IRS will go in there and freeze a judge's bank account. IRS will go in there and freeze a prosecutor's account. IRS don't play games. They will jump in there and freeze your shit, and there ain't nothing you can do about it. So another thing I wanted to talk about is not being able to record or live stream in the courts. You have a right to create your own record. And when they're doing that, they're in they're in breach of their oath of office, breach of public policy. If they have a right to create a record, so do you. And them trying to extort you by getting their record, which is so often manipulated, is a great travesty, and it's something that we as Americans really need to work on to make better. So, what's next? Let's just see what's next. All right. Notice of corporate denial and non-corporate status. Let the record show with the knowledge of the fact, assumption, and presumption may prevail unless rebutted or explicitly denied. I, this asservant, do plainly state that asservant is in no way to be considered, termed as, or thought as a person, legal entity, legal fiction, fictional character, or corporation of any form, with the knowledge that all such entities are not living, breathing, sentient men. Therefore, asservant hereby makes express and explicit claim and affirmation to the living, whose creator is asservant's heavenly Father, and expresses an explicit claim that asservant is not a person or any other form of corporation. The word person is, according to several references and Title 22 USC Section 1621 definitions, for the purpose of this subchapter A, the term person shall include an individual, partnership, corporation, or the government of the United States. Point 001A. The Federal Rules of Civil Procedure, Rule 52, applies in civil and criminal actions with equal force and effect because criminal is always a civil in nature. No civil or criminal cause of action can arise lest there be a contract. See AIDS versus Marks, that's EADS versus Marks. There's always a presumption that a contract exists and that the responding party is a corporation under Rule 52, which is the same in all states. As in the federal rules, the Texas Court of Appeals, Fifth Circuit, has ruled of the findings of facts by the court that the failure of an adverse party to deny under oath the allegations that he is incorporated dispenses with the necessity of proof of the fact. Thus, a presumption becomes a finding of facts, or a finding of fact by the court unless rebutted before trial. Point 001B, Dr. Pepperco versus Crow, Texas Appellate Court, Waco, 1981, no writ. Plaintiff plead defendant was a corporation. Defendant did not deny by verified pleading pursuant to TRCP 52 and 83 that it was not a corporation. Thus, such fact was established. Point 001C, Louisiana Revised Statute, Article 429, corporation existence is presumed unless affidavit of denial is filed before trial. Point 001D, a presumption is a rule of law, statutory or judicial, by which the finding of the basic fact gives rise to the existence of presumed fact until presumption is rebutted. See Van Wart versus Cook. In the commercial law of all states, a presumption means that the judge of fact, must find the existence of the fact presumed per Federal Rule Civil Procedure 52, unless and until the evidence is introduced, which would support a finding of its non-existence. Arizona Revised Statute, Title 47, Section 1201, 31, presumption or presumed, means that their trier of the fact must find the existence of a fact presumed unless and until evidence is introduced which would support a finding of its non-existence. Thus, this affidavit of non-corporate status is for the purpose of rebutting any presumption, and the asservant is the corporation by whatever name or notation. Point 001E, Federal Rules of Evidence, R301, Agreement by Acquiescence. Rule 301 of the Federal Rules of Evidence states, a presumption imposes on the party against whom it is directed the burden of proof See 556D of going forward with evidence to rebut or meet the presumption. 0.001F, when the complaint is lodged by the government for a fine, fee, or a tax, all of which are revenue, they are imposed only on corporations. See Kernel Pipeline versus Triangle. This asservant rebuts any presumptions presuming that asservant is a corporation or general partner to any corporation. Part 001G. Where an asservant is not a corporation, he cannot appear and plead. See West Union Telecommunications Co. versus Iser. Also, Greenwood versus Railroad Co. 123 Massachusetts 32 Foster versus White. I'll survive. I'm not dying. Then again, maybe I am. I don't know. Habach versus Folger. Boyce versus Me Church. And Folsom versus Star Union Electric. Freightline, which was an Iowa case. 0.001H. When a person brought into court by its corporate name, its existence as a corporation is admitted. See Mud Creek Dane Co. versus State. Johnson versus Gibson. Ewing versus Robinson. Callender versus Railroad Co. Com Inc. Co. versus Taylor's. 0.0011. Stating conclusions only is sufficient. It has been held that where the representative of the railroad corporation is served with process, he may plead in abatement in his own name that the corporation is extinct. See Kelly versus Railroad, Callender versus Plansvelo Co., Corey versus Peabody, Everts versus Klingingworth, Stewart versus Dunn, and Stevenson versus Throne. Where the person is so served with that he may, by plea, deny that he, she, sustains any such relation to the corporation that authorizes the service of process, or him, her. See Kelly Railroad. Also, the Supreme Court did not grant corporate personhood to any state of the Union or federal government, and that is the doctrine that this doctrine derives from a mistaken interpretation of the Supreme Court reports notes. See Santa Clara County versus Southern Pacific Railroad Company, 1886. 0.001J. No laws have been passed by Congress granting that corporations under the Constitution should be treated the same as members of the living, breathing mankind. No court's decisions, state or federal, held that corporations were persons instead of artificial persons. In Santa Clara County versus Southern Pacific Railroad, the Supreme Court did not rule on the issue of corporate personhood. Railroad attorney Saunderson and his two colleagues watched as Chief Justice Morrison Remick told Delamus and his two colleagues, the attorney for the opposing party, that the court does not wish to hear argument on the question whether the provisions of the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are of the opinion that it does. This written statement that corporations were persons rather than artificial persons with an equal footing under the Bill of Rights as humans was not a formal ruling of the court, but was reportedly a simple statement by the Chief Justice recorded by the court recorder. See Vermont Supreme Court Building Volume 118 of the United States Reports case, adjudged in the Supreme Court October term 1885 and October term 1886, published in New York in 1886 by Banks and Brothers Publishers and written by J.C. Bancroft Davis, Supreme Court reporter. .001K. Here is the often expressed understanding from the United States Supreme Court that in common usage, statutes employing the terms person and corporations are ordinarily construed to exclude the sovereign man or woman. Wilsons versus Omaha Tribe, 442 U.S. 653, 667, 1979. Quoting United States versus Cooper Corp. 312 U.S. 600, 604, 1941. See also United States versus Mine Workers, 330 U.S. 258, 275, 1947. Additional research into meaning of U.S. citizen. The term citizen of the United States, as found in the qualification clause, is properly construed to mean citizen of one of the states which are united by and under the U.S. Constitution. The construction of one is reiterated in the following passage from Words and Phrases, to wit, citizens of a state within the Removal Act, 18 Stat 473, March 3rd, 1875, meaning citizens of one of the United States. Citizens of one of the United States, and the suits contemplated are suits between citizens of one of the states of the Union on one side and foreign states or citizens of or subjects on the other. Roberts versus Pacific and A. Rye and Navigation Co. 121 F 785 789 58 CCA 61 9th Circuit in 1903. .001K. Here is the often expressed understanding from the United States Supreme Court that in common usage, statutes employing the term person and corporation are ordinarily construed to exclude sovereign men and women. That's Wilson versus the Omaha Tribe. .001L. U.S. Supreme Court in Luther versus Borden, 48 U.S. U.S. 1, 12 LED 581. The government are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. U.S. Supreme Court in Wilson versus Omaha Indian Tribe, 442 U.S. 653, 667, 1979. In common usage, the term person does not include the sovereign, and statutes employing the word are ordinarily construed to exclude it. .001M. Asservant is not a United States person, United States resident, U.S. citizen, U.S. individual, U.S. corporation, or citizen subject to its jurisdiction. As such, are words of art or terms of art, nor is asservant a corporation created under the laws of the United States or any state of the Union States, the District of Columbia or territory, commonwealth, or possession of the United States or any territorial foreign state or country, public or private. .001N. Asservant is not a resident of, inhabitant of, a franchisee of, subject of, ward of, property of, chattel of, or subject to the jurisdiction of, the state of, the forum of any United States corporate state, corporate county, or corporate city, or municipal body politic, created under the primary authority of Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2 of the Constitution for the United States of America, and thereby not subject to any legislation created by or under the jurisdiction of any employees, officers, or agents deriving their authority thereof. Further, asservant is not a subject of the administrative and legislative Article 1 courts, nor bound by precedents of such courts created by the United States, given legislation enacted by Congress applicable to the inferior courts in the exercise of the power under Article 3 of the Constitution cannot be affected by legislation enacted by Congress under Article 1, Section 8, Clause 17 of the Constitution. D.C. Code, Title 11, at page 13, an officer, agent, shareholder, franchise, or fiduciary agent, surety, resident, inhabitant, or domiciled in any corporation. 0.0010. As servant does rescind, revoke, and cancel all of every or of each of as servant's signature on any and all forms, instructions, which may be construed as granting the federal government or any other agency or department of the United States government created under the authority of Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2 of the Constitution for the United States authority or jurisdiction over as servant. 4. On the grounds of constructive fraud and non-disclosure of pertinent facts, as servant does also revoke, rescind, and make void ab initio all powers of attorney, conservatorship, guardianship, or receivership, whether in fact, by presumption, express or implied, or otherwise, signed either by as servant or any person or individual with or without as servant's consent, as such power of attorney may be presumed to pertain to as servant or as servant's persons, by, but not limited to, as presumed by any and all quasi-colorable government entities or corporations. 0.001p. As servant is not a vessel documented under Chapter 121 of Title 46 United States Code, or a vessel numbered as provided in Chapter 123 of said title. 0.001q. As servant does hereby cancel any presumed election made by the United States government or any agency or department thereof, presuming that as servant is or ever has been a citizen, alien citizen, or resident of any territory, possession, instrumentality, or enclave under the sovereignty or exclusive jurisdiction of the United States, as defined in the Constitution for the United States of America in Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2. 0.001r. As servant is neither an enemy of the United States nor enemy ally against nor any corporation created under the either laws of the United States or any state of the Union States, the District of Columbia, Territory, Commonwealth, or possession of the United States, nor a foreign state or country, public or private. 0.001s. As servant's name is a private possession of as servant, and is neither given nor granted to any other without fees assessed. Nonetheless, as servant's Christian appellation is Derek Chaton Gonzalez, or Derek Chaton of the House of Gonzalez, styled Derek Chaton Gonzalez, with location of domicile being where the living man stands on the land, in the land, and may be instantly noticed at the domestic carrier route mail location. 0.001t. These averments support by affidavit is not averred from the purpose of debating constitutionally or legality of the Communication Act of 1934, but rather to raise the specter exposing the United States government lack of jurisdiction in these matters, as servant is not a pirate affiliated with or an enemy of any public or private corporation, domestic or foreign, but rather asservant is a neutral body. Any past or future reference to asservants ex rel, any fiction referenced by any agency or its officers, is deemed defamation of character and false and misleading statements. Title 15 USC 1692E 78 FF, and that may expose offenders and all liabilies to good faith immunity waiver and their volunteering to litigation and or assessment in their jurisdiction under with the Admiralty, Title 28 USC 1333 or 1337, Bills of Lading Act, the Public Vessel Act, Foreign Sovereign Immunity Act, False Claims Act, Federal Arbitration Act, Declaratory Judgment Act, given that any of the facts of laws presented herein are not contrary to the Communications Act of 1934. All facts averred or averred herein are to the best of the asservant's research and belief, whereby asservant has not seen any facts or evidence that any of these herein averred facts, averments, have been determined to be frivolous, as determined by the court of competent jurisdiction. Where averred within their exact and proper context, these averments are technical facts that under commercial law must be point for point expressly rebutted and respondents sworn first-hand personal knowledge via counter affidavit with supporting facts and evidence in sworn first-hand personal knowledge via counter affidavit with supporting facts and evidence in support thereof, all sworn to be true, correct, complete, and not misleading. By misrepresentation of omission under respondents, full unlimited commercial liability to avoid nihil dicet tacit procurement acquiescence. 0.001U. Any statements or claims averred herein must be properly rebutted by facts of law or overriding Article 3 Supreme Court rulings, and shall not prejudice the lawful validity of the claims not properly rebutted and invalidated by facts of law. Therefore, any affidavit of truth under commercial law can only be satisfied, I, through a rebuttal affidavit of truth, point for point, or 2, by plaintiff, or 3, by agreement, or 4, by resolution by a jury under the rules of the common law. 0.001V. Further, asservant denies having or ever having had a birthday, but rather asservant does have a nativity upon the soil of Arizona and the Republic thereof, and asservant does celebrate asservant's day of conception. 0.001W. Asservant expressly avers that asservant is an adverse party ex rel, any presumption of corporation existence, and asservant does deny any allegations that asservant is incorporated, and the closing unrebutted averments underscored by asservant's wet ink autograph and landmark imprints its asservant's express proof of the facts that asservant is the expression of the living God here on earth, as per the failure of an adverse party to deny under oath the allegations that he is incorporated with the necessity of proof of the fact. It becomes part of the official record. Geller Bank versus Southwest Properties. Sorry, this is a little long and I've got some notation to make in here. Boom, boom, boom. All right. Use, misuse, and abuse of words to change the meaning. Webster's 1828 dictionary says this under birth. Birth, that's B-I-R-T-H or B-E-R-T-H, and born, all come from the same root of to bear. When you look up birth, B-E-R-T-H, you find out that every definition has to do with ships. So our birthday is the day we were given a place within the Maritime Admiralty jurisdiction of the state. Webster's New World Dictionary of the English Language, 3rd College Edition, copyright 1988, page 132, birth, B-E-R-T-H, noun, for a position, place, office, job, etc. We perceive that this B-E-R-T-H, birth, is the office of person aboard a ship of state. A living soul has a date of nativity, with life begins at the moment of conception, while on the other hand, a corporation soul has a date of birth, or B-I-R-T-H or B-E-R-T-H. There are only 2 birthday parties in the scripture, and in both cases a man lost his head. At Pharaoh's birthday party in Genesis, the baker was hung, and at Herod's birthday party in the Gospel, John the Baptist was beheaded. So, how did a Christian culture end up celebrating birthdays as is customary? Somebody had a plan, and that plan involved embedding the number of the beast into our consciousness at a very early age as possible. The 3rd birthday was mentioned in the Holy Writ. Note that the 666 talents of the gold mentioned below did not include all that was brought by merchants' means. 1 Kings 10:14 and Chronicles 9:13. Now the weight of the gold that came to Solomon in 1 year was 666 talents of gold. Wherefore I do inform the Nice Police Mobile Revenue Enforcement Agency peace officer, the bureaucrat, the de facto court system, and all other parties that may make inquiry. I, as I am, have no birthday, even backing that with no man can be compelled to incriminate himself. Memorandum of Law, points of authority in support of non-corporate status averments. The Federal or Civil Procedure Rule 52 applies in civil and criminal actions with equal force and effect because criminal is always civil in nature. No civil or criminal cause of action can arise lest there be a contract. See Eads, E-A-D-S, versus Marks, 249, page 2D, 257, 260. There is always a presumption that a contract exists and that the responding party is a corporation under Rule 52, which is the same in all states as in the federal rules. The Texas Court of Appeals, 5th Circuit, has ruled on the findings of facts by the court that the failure of an adverse party to deny under oath the allegations that he is incorporated dispenses with the necessity of proof of that fact, or of the fact. Thus, a presumption becomes a finding of fact by the court unless rebutted before trial. A presumption is a rule of law, statutory or judicial. Oh, I'm just repeating myself. Yeah, it's just rhetorical. Anyway, I just wanted to share that with you guys this morning, a little corporate denial. I've got some hiccups in there I need to go clean up, so duly noted on that. What else can we get into here? The 12 presumptions of law. The 12 presumptions of court, Canon 3228. A Roman court does not operate according to any true rule of law, but by presumption of the law. Therefore, if presumption presented by the private bar guild are not rebutted, they become fact and are therefore said to stand true, or as truth in commerce. There are 12 key presumptions asserted by the private bar guild, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor beneficiary, executor de jure tort, incompetence, and guilt. And a definition of presumption, an idea that is taken to be true on the basis of probability. As a presumption is a presumption on which must be agreed by the parties to be true. Then, and equally, if one party challenges the presumption to be true on the basis of probability, then this is all that is recognized to be required to remove the presumption is a formal challenge to that presumption. The presumption then has no standing or merit in fact. A probability, the extent to which something is probable, the likelihood of something happening or being the case. By definition, then this is not substantive, as it is only a probability of what may be, and, therefore, has no substance in material fact. A state court does not operate according to any true rule of law. By presumption of the law, therefore, if presumption presented by the private bar guild are not rebutted, they become fact and therefore said to stand true. 1. The presumption of public record is that any matter brought before the state court is a matter of public record when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter, unless openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter completely under the private bar guild rules. I, the undersigned, formally challenge the presumption of public record, as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government, or public officials by making additional oaths of the public office that openly and deliberately contradict their private superior oath to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. I, the undersigned, formally challenge the presumption of public service, as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. The presumption of the oath of public oath is that all members of the private bar guild, acting in their capacity of public officials who have sworn a solemn public oath, remain bound by that oath and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. I, the undersigned, formally challenge the presumption of public oath, as it is by definition a presumption, and by definition, and has no standing or merit in presentable or material fact. The presumption of immunity is that key members of the private bar guild, in the capacity of the public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith, are immune from personal claims or injury and liability. Unless openly challenged and their oaths demanded, the presumption stands that the members of the private bar guild, as public trustees, acting as judges, prosecutors, and magistrates, are immune from any personal accountability for their actions. I, the undersigned, formally challenge the presumption of immunity, as it is by definition a presumption, by definition, and has no standing or merit in material or presentable fact. The presumption of The presumption of summons is that by custom a summons unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, witness, which are all fictions, and jurisdiction of the court. Attendance to court is usually invitation by summons, unless the summons is rejected and returned, with a copy of the rejection filed prior to choosing to visit or attend jurisdiction and positions as the accused and the existence of guilt stands. I, the undersigned, formally challenge the presumption of summons, as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. The presumptions of custody is that by custom, a summons or a warrant, which is really a capias for arrest, unrebutted stands, and therefore one whom attends court is presumed to be a thing and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood soul possessing beings, unless this presumption is openly challenged by rejection of summons and or act of court or at court. The presumption stands you are a thing and property and therefore lawfully able to be kept in custody by custodians. I, the undersigned, formally challenge the presumption of custody, as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. Number 7, the presumption of court of guardians is that the presumption that as you may be listed as a resident of a ward of a local government area and have listed on your passport, letter P, you're a pauper, and therefore under the guardian powers of the government and its agents as a court of guardians, unless this presumption is openly challenged to demonstrate you are both a general guardian and a general executor of the matter trust before the court, the presumption stands and you are by default a pauper and lunatic, and therefore must obey the rules of the clerk of guardians, clerk magistrate of the court. I, the undersigned, formally challenge the presumption of guardians, as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. The presumption of the Court of Trustees is that members of the Private Bar Guild presume you accept the office of the trustee as a public servant and government employee just by attending a Roman court. As such, courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged to state you are merely visiting by invitation to clear up the matter and you are not a government employee or a public trustee in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction. Excuse me. Simply because you appeared. I, the undersigned, formally challenge the presumption of trustee, as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. Number 9, presumption of the government acting in two roles as executor and beneficiary is that, for the matter at hand, the Private Bar Guild appoints the judge, magistrate in the capacity of executor, while the prosecutor acts in capacity of the beneficiary of the trust for the current matter. If the accused does seek to assert their right as executor and beneficiary over their body, mind, and soul, they are acting as executor dijon tort, false executor, challenging the rightful judge as executor. Therefore, the judge magistrate assuming the role of true executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation unless this presumption is openly challenged to demonstrate you are both the true general guardian and general executor of the matter trust before the court, questioning and challenging whether the judge or magistrate is seeking to act as executor dijon tort. The presumption stands and you are by default the trustee, therefore must obey the rules of the executor judge magistrate, or you are executor dijon tort and a judge or magistrate of the Private Bar Guild may seek to assistance of bailiffs or sheriffs to assert their false claims against you. I, the undersigned, formally challenge the presumption of government acting in two roles as executor and beneficiary, as it is by definition a presumption, by definition, and has no standing or merit in presentable or material fact. Number 10, the presumption of agent and agency is the presumption that under the contract law you have expressed and granted authority to the judge and magistrate through the statement of such words as recognize, understand, or comprehend, and therefore agree to be bound to a contract. Therefore, unless all presumptions of agent appointments are rebutted through the use of such formal rejections as I do not recognize you, to remove all implied express appointments of the judge, prosecutor, or clerks as agents, the presumption stands and you agree to be contractually bound to perform at the discretion of the judge or the magistrate. I, the undersigned, formally challenge the presumption of agent and agency, as it is by definition presumption and by definition and has no standing or merit in presentable or material fact. Number 11, the presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge magistrate as executor has right to have you arrested, detained, fined, or forced into psychiatric evaluation unless the presumption is openly challenged to the fact that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions. Then you stand by the time of pleading that you are incompetent, then the judge or magistrate can do whatever they need to keep you obedient. I, the undersigned, formally challenge the presumption of incompetence as it is by definition a presumption by definition and has no standing or merit in presentable or material fact. Number 12, the presumption of guilt is the presumption that as it is presumed to be a private business meeting of the bar guild, you are guilty whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice onto the public record, or call a demur, then the presumption is you are guilty and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. That's why the IRS is so important. I, the undersigned, formally challenge the presumption of guilt, as it is by definition a presumption by definition and has no standing or merit in presentable or material fact. I, a man, Derek, do say all herein is true and will verify in open court. Let the record show that I, a man, Derek, do challenge the 12 presumptions of law before and against all claimants, complainants, libelants, trespassers, petitioners, respondents, inquisitors. So with that said, I will let you guys go this morning. I'm just going through some of my court paperwork that I put up there. As always, we want to take judicial notice of the 20 maxims in equity. Equity sees that as done with what ought to be done. Equity will not suffer a wrong without a remedy. Equity delights in equality. One who seeks equity must do equity. Equity aids the vigilant, not those who slumber on their rights. Equity imputes an intention to fulfill an obligation. Equity acts in personam. Equity arbors a forfeiture. Equity does not require an idle gesture. He who comes into equity must come with clean hands. Equity delights to do justice and not by way of halves. Equity will take jurisdiction to avoid a multiplicity in suits. Equity follows the law. Equity will not aid a volunteer. Where equities are equal, the law will prevail. Between equal equities, the first in order of time shall prevail. Equity will not complete an imperfect gift. Equity will not allow statutes to be used as a cloak for fraud. And equity will not allow a trust to fail for want of a trustee. Equity regards the beneficiary as the real owner. He who occasioned the loss must bear the burden. Thank you for joining me this morning. I hope this stuff helps you out in your journey and your quest for seeking the truth. I have a little bit of corrective measures that I need to do on my paperwork, obviously. I just noticed those. And so that's the importance of reading, rereading, and reading again. So I hope this all helps you guys out, and we'll talk to you guys soon.